Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast, Tolling Time Frame Edition. I'm your host, Bridget Flaherty. On October 1st, 2017, the Supreme Court heard argument in Artis v. District of Columbia, a case involving a dispute over the meaning of tolling as the term is used in the Federal Supplemental Jurisdiction Statute, Title 28 of the United States Code, Section 1367D. In April 2009, Stephanie Artis, a temporary employee for D.C.'s Department of Health, filed a claim with the U.S. Equal Employment Opportunity Commission, EEOC, alleging discrimination by her supervisor, Gerard Brown. Artis followed the charge with a series of grievances challenging notices of proposed infractions against her and alleging other violations of employee rights by Brown. The DOH terminated her employment in November 2010, and she lodged a final grievance in January 2011, alleging the termination was unlawful retaliation. Artis filed suit against D.C. in federal district court in December 2011. She asserted a federal claim of unlawful termination in violation of Title VII of the Civil Rights Act of 1964, along with various other claims arising under D.C. statutes and the common law. In June 2014, the district court granted D.C. judgment on the pleadings and dismissed Artis' sole federal claim under Title VII. Given the facial deficiency of that claim, the district court found no basis for exercising supplemental jurisdiction over Artis' remaining non-federal claims. 59 days later, Artis refiled those remaining claims in D.C. Superior Court. D.C. responded with a motion for dismissal on the grounds that the claims were time-barred based on the relevant statutes of limitations, plus Title 28 of the United States Code, Section 1367D, of the Federal Supplemental Jurisdiction Statute. The Supreme Court agreed, concluding that 1367D does not suspend state statutes of limitations at the time of an unsuccessful federal filing, but rather creates a 30-day period for a claimant to file actions over which the U.S. District Court lacked jurisdiction. The language of 1367D provides that statutes of limitations shall be tolled while the claim is pending and for a period of 30 days after it is dismissed, unless state law provides for a longer tolling period. On appeal to the D.C. Court of Appeals, Artis argued that there were nearly 2 years remaining on the statute of limitations when she filed her suit in the federal district court, and, under the language of 1367D, she had that period plus 30 days to file her claim in Superior Court after her case was dismissed. D.C. countered that tolled should merely mean that a 30-day grace period applies if the limitations period for the non-federal claims expires, as it would have in Artis' case, while the federal claim is pending in federal court. The D.C. Court of Appeals found D.C.'s grace period more persuasive, as Artis had failed to refile her remaining claims within that grace period following dismissal. The Court of Appeals deemed them time-barred and affirmed the judgment of the Superior Court. The U.S. Supreme Court granted certiorari to address the dueling interpretations of 1367D, whether that provision suspends the limitations period for a non-federal claim while the claim is pending and for 30 days after the claim is dismissed, or whether the tolling provision does not suspend the limitations period, but merely provides 30 days beyond the dismissal for the plaintiff to refile. And now, to discuss the case, we have Misha Tutzlin, Solicitor General of Wisconsin.
Artis raises the issue of what happens when you file a federal claim in federal court, and supplemental to that claim, you also bring some state law claims. What happens if further the case runs for a couple years before the district court dismisses your federal claims on the merits or otherwise, and then also dismisses your state law claims, but such that you would like to refile your state law claims in state court? Sometimes, in that circumstance, the statute of limitations for your state law claims will have run such that you would be out of luck in state court. So Congress decided to dissolve this issue by enacting a statute, which provides that the limitations period shall be tolled during the pendency of your state lawsuit and for 30 days thereafter, unless the state law provides for a longer limitations period. Now, in this case, the plaintiff sued the District of Columbia under federal and state employment discrimination law in federal court. Eventually, the federal lawsuit was dismissed, and plaintiff wanted to refile just the state law claims in state court, or more particularly in District of Columbia courts. But the plaintiff waited more than 30 days to refile. So the question became whether his state law claims were timely under District of Columbia law, or whether they were no longer timely. Now, the plaintiff has an interpretation of that statute that would provide that the entire time that the plaintiff's claim was pending and 30 days would be added to the statute of limitations period. So if you file a federal claim with state law claims supplemental to them with 3 years left on your state law statute of limitations, and the claim is then pending for 2 years in federal court, you get an extra 2 years before it is dismissed by the federal court. If you want to refile in state court your state law claims, you get an extra 2 years and 30 days to refile in state court. The plaintiff argues that this is the ordinary meaning of the term toll. On the other side of this case, the respondent argues that the statute is just a 30-day refiling period, unless the state law provides for a longer limitations period. The function of that statute, the District of Columbia argues, is to keep your state law claim from expiring during the pendency of your federal lawsuit, such that the happenstance that you had a supplemental claim that was attached to a federal claim that ultimately failed would not put you out of luck in state court. Now, the state of Wisconsin became involved in this lawsuit because the statute at issue deals with not only District of Columbia claims, but also with state law claims of states around the country, including the state of Wisconsin. So the Wisconsin Attorney General, on behalf of the state of Wisconsin, and a bipartisan coalition of 24 states, filed an amicus brief in the Supreme Court. And what we argued was that the plaintiff's approach, which could extend state law statute of limitations periods for years, for cases that are going to be filed under state law in state court, would exceed Congress's authority under the necessary and proper clause. We argued that Congress's authority with regard to these supplemental claims that were dismissed ends at the period where Congress provides for a way for those claims to be refiled in state court, such that there is no harm to the plaintiff from being unsuccessfully in the federal forum. That if instead, as plaintiff urges, Congress was going significantly beyond that and adding years onto state law claims when they come back to state court, that would exceed Congress's authority under the necessary and proper clause. And we further argued that because, at minimum, plaintiff's argument would raise serious constitutional and federalism problems, as a matter of avoidance and the federalism clear statement rule, the District of Columbia's interpretation should prevail. Now, last week, there was oral argument in this case in the Supreme Court. The petitioner went first and immediately drew fire from Justice Kennedy on the meaning of the statutory text, and especially on that last, unless state law provides for a longer limitations period clause. Justice Kennedy pointed out that petitioner's theory would seem to make that last clause not very meaningful. Plaintiff was also criticized by Justice Alito, the Chief Justice, and Justice Sotomayor for the federalism implications and the disrespect for state court and state law inherent in the petitioner's position. When the District of Columbia's attorney stood up, she drew significant fire from Justice Kagan, Justice Ginsburg, Justice Breyer, and to some extent from the Chief Justice on the plain meaning of the word toll. Those justices, especially Justices Kagan and Breyer, indicated that it was their sense that toll usually means stop clock tolling. That is, if you have a tolling period that stops the period of limitations from running during the pendency. As you can see from my summary of the question the justices asked, it is very difficult to determine who will prevail in this case based upon the arguments and the questions at oral argument. On one hand, there didn't seem to be a decent number of justices that were concerned with the District of Columbia's approach with this textual interpretation, but in particular with the federalism implications of that position as urged by the 24-state bipartisan amicus coalition. On the other hand, there was certainly strong opinion expressed by several justices that petitioner had, in their view, the better understanding of the word toll. So I think the best prediction I can make is that it will be a struggle between the very serious federalism implications of petitioner's view and the sense by at least some of the justices that toll should, in the general case, mean more what the petitioner is saying than what the District of Columbia is saying. The decision in this case is expected by the end of this term, and while this may not be the most highly watched case in the media, we in the states, in particular in the state of Wisconsin, will be closely watching and anticipating that decision.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.